Yes, welcome to the No Stay Project here on whoa, almost making my first mistake there. This is on my YouTube channel, so it's still early in the show, so I don't think anybody actually caught that potential error there. But this is the No Stay Project, talking about anarchy, government abuse, and defending yourself in court. And it is episode 99 of the big show. So, yeah. Coming to you from the fortified compound in Mesa, Arizona, and glad to be with you here. A lot of stuff to get to. You want to join me? Well, it's in the description, so still have a lot of stuff to talk about. I want to thank everybody for the continued support of the show. Can't do the show without it. I do appreciate that. If you want to help support the show, it is in the show in the description. So it is markstevens.cells.com. You can also just go to my website, markstevens.net. And you can do that through PayPal. It is episode 99 of the big show. It is the 13th of February 2009. And what I mean by anarchy, to define the term, is just from the literal translation of the Greek, which is no ruler. We don't believe that there should be a violent ruling class in society, that it is wrong to lie, steal, kill, and cheat people just because you call yourself a government. And we reject the notion, or if you can call it a philosophy, that it is people called government have a moral right. That's what's so sick about it. A moral. If you support the idea of government, your basic philosophy is that concerning that is that it is okay. Or that it is morally, they have a moral right to do what is immoral. And yes, I do read the chat there, Skiba, no, I don't know what that means, but yeah. Oh, it says 98 in the description? I guess that's a typo. It is episode 99. I am expecting some calls. We got a lot of people going to court in the next few weeks. One in particular, someone I've been working with in California. I've reported this stuff, a lot of this on the show before. But he's got a hearing coming up. This is where it's invalid on its face. So whether you are an anarchist or a minarchist or a libertarian or a socialist, a Democrat or a Republican, 100% garnishment is not supposed to be allowed. 100%. And don't go thinking, oh, you can just sue the employer, because the employer has absolute immunity. As long as they're doing it based on an order from the IRS, there's immunity. That you can't touch them. And so what we're doing is judicial review. And I don't believe the Anti-Injunctive Tax Act applies there, but what they have are these laws called the Anti-Injunctive Tax Acts. And in the federal proceedings, it's section 7421, which does not, the enactment of the Comparable Tax Injunction Act of 1937, which is 28 U.S.C. section 1341. Sorry about that. Forbidding the federal courts to entertain suits to enjoin collection of state taxes where a plain, speedy, and efficient remedy may be had at law or in equity in the courts of such state. But there's also one for the federal. So that probably must be where section 267421 comes in. Yeah, 7421 is for barring federal jurisdiction to enjoin the collection of taxes. There is an exception, which we're going to talk about here. And I've spoken about the, proof of systemic bias that the IRS has in their favor, in that, and the state taxing agencies, especially California, have been able to enjoy this systemic bias because and proof of this is the fact that uniformly, and we're hoping this does not happen with this case that's coming up March 14th in California, but uniformly even when we try to get a petition for writ of mandate to force judicial notice in California of exceptions to the Anti-Injunctive Tax Act, they won't do it. So no federal judge, and granted, it's been more than 5 years since I am been involved with something where we're trying to get a complaint in federal court to stop the taking of someone's property, under the guise of taxation. And we have not been successful in not one single judge. Again, you can be a Republican or a Democrat or whatever stripe, whatever you are as a critic. You can even be an anarchist who just can't stand my work. You cannot deny that there are exceptions to the Anti-Injunctive Tax Act. And there's no way to support judges at the federal and state level for 20 years. Okay, well, let's just say from 97 to 2010 to be safe, that every single one of them has refused to acknowledge that this law, that the exception even exists. So whatever you think of me is completely irrelevant to whether there's, to that. You can say, well, Mark, you're just full of crap. Judges do recognize that. In my experience, when we bring these actions against them, every single time they have refused to even acknowledge it. It's not that they're saying, yes, Mark, or whoever it is, Mr. X, you're right, there is an exception to the Anti-Injunctive Tax Act, but your complaint doesn't fall within that narrow, and I know it's a narrow exception, I know, but they don't say that. They don't say that you don't have sufficient facts, or they don't say, well, your facts, even taking as true in the most favorable light to you, still don't put this within the exception. The exception exists, but you don't meet it. They've never done that. That's why, that is a big reason why on the back of Adventures in Legal Land, the monkeys, because they ignore the law. And at the time, that was a really hot button issue back in 2002, 2003. And we had established a 5 or 6 year record of every single judge. Well, no exception. And I'll go through in a few minutes the actual exception. I'll give you the citation. Because there is one, not just at the state level, like in California, that I've discovered, I've mentioned, like the Western Oil and Duke Majan cases. It is at the federal level, but hopefully, when we go through this with Greg in a few weeks, the judge is going to apply, at least acknowledge the exception, and do the right thing, and apply the actual, facts, and see if those facts. So let's discuss the actual facts here. No, for those who are new, maybe not familiar with the way I tend to do things. No, I'm not ranting. I'm half Sicilian, and that's just something that we Sicilians do. We talk, I could do it. I am fluent in Sicilian Sign Language. So it's not ranting. This is that's Sicilian ranting. So talking with my hands is a Sicilian thing. It's not. I'm not ranting. So those who may not be familiar with the way I do things, I like to stick to the facts. I like taking somebody's argument or someone's claim, whether it's legal, it doesn't matter. But here we're dealing mainly with legal allegations and legal claims. And I like to attack those on the facts, whether they have facts. I don't like to make legal arguments or pure issues of law or interpretation and say, well, I'm not a taxpayer within meaning a statute. No. I like to strike at the root and say that it doesn't matter how you're defining, how your code defines taxpayer. I don't care. I don't care what it says about income. I want the evidence you rely on that it applies to me in the first place. Okay, so we attack the foundation. We attack it and make it an issue of fact. Because the courts have already ruled, Helving versus Taylor, Adamson versus Commissioner, the IRS does not enjoy a presumption of correctness unless it is based on facts. Got to be based on facts. It's got to be reasonable, rational. making an assumption like I had an agent admit a couple of months ago with the Franchise Tax Board. An assumption is not reasonable and it is not rational. Now, things are supposed to be fair. Now, we know that if we make an assumption that they're not going to accept that, in fact, we've had things thrown out that even though we had a mountain of evidence, the judges turn around and say, you're just making a conclusory statement. You have no evidence to back it up. Like, I think that's a really, really good principle, and I think that we should all be held to that. But why are you only holding me, the defendant, to that? Why aren't you holding the IRS to that? Their entire case, except for the amount, is literally conclusory statements. But there's no evidence to support it. So let's look at what happened here. You know what I like to do is I like to get the agents on record. I want their actual admissions that I could use against them. So we've got a number of really good admissions, okay? And again, this involves a 100% garnishment. And we've been trying for months to get this to stop. The IRS was able to get a stay. Oh, but us, hey, oh my gosh. No, not so much. So we are looking to get an initial injunction, a temporary injunction, until we can have some kind of evidentiary hearing to determine the merits of this complaint. Do the facts as alleged, if taken as true, not only fall within the narrow exception of the Anti-Injunctive Tax Act, do they entitle him to relief? So these are some of the statements. Now we have dates and times and recordings. And I am a witness to this. So, the client's on the line, Greg's on the line with me, and they give he gives third-party authorization for the IRS to speak to me. So we do it. So we have an Agent Mullen, and I believe that they were out of Holtzville, Long Island. Hey, I grew up right around the corner from this criminal headquarters. Yeah, just on the other side of Bald Hill, for those from Long Island, if you know, I'm on the other side of Bald Hill. And so when you go south, or over Bald Hill, on the way down, when you get into Holtzville there, after you get to the bottom, then, it was at the east side of 112 is the, so anyway, I'm speaking to this Mullins, and Mullins is insisting that asking them for the facts that their legal allegations or claims are based on, which have to be based on facts, Helvering versus Taylor, Adamson versus Commissioner, right? We'll have it in the video. Just asking them and challenging the factual basis of their claims, she says, is frivolous. Now, I don't doubt there's some scumbag judge that has, yeah, that's brilliant. Sure. Judges are so incredibly biased in favor of the IRS that they may say things like this. I had a federal judge and an appellate panel in California lie that we did not have any evidence. It's the whole conclusory statement. It didn't matter that we had a partial transcript of the phone call. Oh, and that's right. We had a copy of the call that put the agent's credibility at issue. Oh, and what facts, what testimony, what statements do we have that put the agent's credibility at issue? His own admission. Evan Moses actually admitted to not being qualified to have made the conclusions and statements that were in the affidavit of good faith. The judges lied. Four judges lied that there was no CD. They didn't even acknowledge the partial transcript we had. They just lied. So that is institutional bias. How could that possibly survive appeal? We had a CD. No one on the appellate panel acknowledged it. Why? Because it's called bias. Oh, but Mark, you're saying that the judges like paying taxes? Maybe, maybe not. But that does not negate the fact that they are so biased. It's not negating the fact that they're lying. So this whole thing, well, Mark, you went to court and you lost. Well, do you look at why? How can anyone actually prevail if the judge is literally lying and not acknowledging the evidence on the record? Oh, so again, like I've mentioned before, pull your puckered lips off the judge's ass long enough to look at the facts. If you dispute that, that's fine. Go and dispute the facts. We can prove that. They didn't say that the partial transcript of the call was wrong. They just said it wasn't there. They weren't disputing the facts. Oh, why is that? Because they don't dispute the facts, because that has to be determined with a hearing. And they don't want to have a hearing. So, all these cheerleading scumbag bottom-feeding lawyers who say that I'm a scammer, well, there's only a few, pull your mouth off that judge's dick for just a moment and look at the facts and see what actually happened instead of just accepting the decision in a vacuum. But again, stop filleting the judge. You're gonna have to stop filleting the judges long enough to actually take an objective look at the record. Okay? So we know that the IRS is lying through their teeth by saying that the courts have ruled that it is a frivolous argument to challenge the factual basis. Because even if you have a trial court judge that said that, there are hundreds and hundreds and hundreds of court cases at the appellate level and the Supreme Court. It's a basic defense to challenge the factual basis of the argument and claims being used against you. And the day that becomes a part of due process, that challenging the factual basis of a claim is frivolous, all pretense of fairness and due process are gone. They're gone. That would be the equivalent of them treating murder, rape, real crimes, just like they do in IRS cases in the tax court, and just the way they run their traffic courts. All pretense is gone. All. The only defense, you don't have a defense. You don't have a peaceful defense. The facade is gone. We're criminals. We have jurisdiction because we said so. And there is no due process other than pay or go to jail. But we're still at a point where they're trying to make it look good. So we go up the chain. We're actually with the agent named Marconi, and it really is disappointing if that's his real name, that he might actually be a paisan. I think he's more of a Goomba at this point, but Marconi, Mr. Marconi, admittedly doesn't have any evidence to support his claim. None. He admits it. Why can he admit that he has no evidence? Why can they be so bold where even police officers won't say on the record, I got nothing? Because when you get them on cross-examination, they got to judge to bail them out. Oh, the witness is not competent to testify. Even though you're asking for the facts, I'm going to be a bottom-feeding scumbag, and I'm going to say it called for a legal conclusion. How about fungal with your due process? But the cop doesn't come out and say, I got nothing. The IRS is so protected. There isn't an anti-injunctive act against the police that you can't put them on the stand when they write a complaint and make allegations against you. You imagine they try to treat traffic, they can't even treat traffic court that way. Oh, you don't get to you don't get to have a trial. You have to pay and then you can have a trial. Well, yeah, I know you have to put a bond up, but they don't find you literally guilty and then you can contest it after. So, yeah, it is a mafia mentality because it's organized crime. There's no doubt that's what the facts say. Yeah, are we getting more of this crap? I real quick. I've been called a shoe for the Jews. I am a shill for the Jews because I'm a skeptic on these so-called fake events. I'm shilling for the Jews. Yeah, if I wrote that down, I forgot because it's really not that important. I'm a shill for the Jews. You got me. I've even said my favorite guitar players, Peter Greenbaum, Michael Bloomfield, Jew. What a stupid thing I'm showing for the Jews. All right, so we have Mr. Marconi, who is admitting, like Evan Moses and like they typically do, they don't have any evidence. They're just making an arbitrary claim. Hey, this applies to you and creates obligations and gives jurisdiction. Do you have any proof? I don't have any evidence. So we go up to Mr. Jones, the supervisor. Not only does Mr. Jones, the supervisor, confirm that Marconi has no evidence, admittedly, he states we don't even need evidence. Oh. Silly me. So I even asked him, so you believe that proceeding absent evidence of jurisdiction is consistent with due process? Yes, I do. Kind of reminded me of the scene where Chuck McGill, who's the actor from Lenny from Lenny and Squiggy from Laverne and Shirley, Michael McKean, and of course Nigel. No, he wasn't Nigel, but he Spinal Tap, and he's playing a cop, and he's questioning John Candy in Planes, Trains, and Automobiles. He says, "You have no roof, you have no windows, you have no light, you have no windshield. Your cars are melted. Your tires are melted. Do you believe that this car is safe for highway use?" Yes, I do. Yes, I do. So, Agent Jones believes that it is fair and consistent with due process to proceed knowing you have no evidence of jurisdiction. Wow. So then this matter is, we try to appeal this, and now we have an appeal agent who is named O'Neill, and he goes one further. He admits that the IRS can't prove these claims. So follow along with me if you will. I have to put this in a video so it's easy for us to follow, because it's a little involved if you're not used to this kind of stuff. First, we have asking for the facts is just alone, challenging them on the facts. Frivolous. Then we have Marconi, I got nothing. I dug down deep, I got nothing. Then we've got his boss saying, we don't need it. He doesn't have it. We don't need it. That's fair. Okay? I can allow us to get away with that. Not that I'm asking. Then we have the appeals guy, who's supposed to be fair, impartial, and independent. Right? The IRS can't prove it. And apparently, they don't need to. Why? Oh, because you got a prison system. Okay? Now, this gets me to, of course, the case I was talking about. Now, this is Enochs versus Williams Packing and Navigation Company, Inc. 370 U.S. page 1. Hell of a case to start this new report. Maybe it was the beginning of that particular session. I don't know. It's not important. Wow. This is quite something, because you have the Anti-Injunctive Tax Act. It takes jurisdiction away from the district court against any complaint that seeks to enjoin the collection of a tax. And it's trying to stop a 100% garnishment is trying to stop the tax. Now, for all you people screaming about common law, that's the common law in taxation is pay first, and if you're not economically destroyed, maintain an action against a literal army of lawyers. Now, they are called the Attorney General. You have a literal army of lawyers that have an unlimited budget against you to try to get your money back. Yeah, good luck. Now you understand, and now it comes clear. Why do they hit you with such unbelievable fines and penalties where no rational person could think you owe $5 million? Oh, that's right. That's how you foreclose somebody's common law remedy. Because you can't pay it. You can't pay it. Like I said in court, what an honest criminal does, well, a more honest criminal does, they physically kill the victim. Kill you. With the IRS and these criminals called government, what they do is they economically murder you. You can't possibly pay. It's like the tax court. They can give you the most ridiculous judgment, and you never get it reviewed. Why? Because they hit you with $25,000 fines on top of a new assessment, and you gotta pay for it. So there's your friggin' justice, right? Yeah. They're not stupid. Hey, just make the fine so much you can never get it reviewed. How about fungal? Yeah, so we said there was no right of cross-examination. So we refused to strip them of they had no facts, and we refused to comply with the rule and strip them of their presumption of correctness. How about fungal? What, you think we're here to be fair? Pay or go to prison. Which one do you want? Okay? So we get down to the part where they ignore. They say the manifest purpose of the Anti-Injunctive Tax Act is to permit the United States to assess and collect taxes alleged to be due without judicial intervention and to require that the legal right to the disputed sums be determined in a suit for refund, right? If you can pay. In this manner, the United States is assured a prompt collection of its lawful revenue. Nevertheless, this is the big part here. Nevertheless, if it is clear that under no circumstances could the government ultimately prevail, the central purpose of the act is inapplicable, and under the nut margarine case, the attempted collection may be enjoined if equity jurisdiction otherwise exists. In such a situation, the exaction is merely, quote, in the guise of a tax, end quote. Now here they said, we believe that the question of whether the government has a chance of ultimately prevailing is to be determined on the basis of the information available to it at the time of suit. What is available at the time of this suit? Provided they acknowledge this. Provided they acknowledge that if it is clear that under no circumstances could the government ultimately prevail, the central purpose of the act is inapplicable, and the court does have jurisdiction. This is the key. This is it. If you just refuse to acknowledge the law and the requirement as a judge, and you just put your, I don't see it, I don't acknowledge it, I won't breathe a word of it. Because my master, they're not going to go against they're not going to do it. Yes, they may rule against the IRS here and there on matters of money, numbers. I don't know, something like this. Especially when they got one of the plebes who doesn't have the money to pull out to be able to get appeal. We believe that the question of whether the government has a chance of ultimately prevailing is to be determined on the basis of the information available to it at the time of suit. That information here is, 1, asking for facts is frivolous. That is a lie. That is a felony. You put that through the mail to take someone's money, that is called mail fraud. That is a false statement to get someone's money. False. Adamson versus Commissioner. Marconi admitting, I don't have any proof. I have no evidence. Jones saying, Marconi doesn't need evidence, and it is fair to proceed against you and take 100% on a garnishment, which is supposedly not supposed to be legal. We're going to do it anyway. We don't need evidence. And O'Neill admitting they can't. Those are the facts. We have the dates, the times, who we spoke to. Given that set of facts, do those facts, taken as true, for the purpose of their motion to dismiss, which under Rule 12b, when you file a motion to dismiss, you are omitting all well-pleaded facts, and the judge has discretion to only construe those facts as true and most favorable in light to the plaintiff. How else can you interpret, I don't have any evidence, I don't need any evidence, and we can't prove that? How else are you supposed to interpret that? Favorable to the plaintiff. That means the only real plausible explanation of those facts is that under no circumstances, given those facts, could the IRS prevail. And given that, it falls within this narrow exception to the Anti-Injunctive Tax Act. But what we'll have to see is if it will play out as it has in prior years. Are they going to acknowledge the Anti-Injunctive Tax Act? Because the very act of acknowledging that and complying with the rules governing Rule 12b, which is motion to dismiss, if you acknowledge the exception and then you also accept the facts as pled, as favorable to the plaintiff, you can only conclude that the IRS cannot prevail under any circumstances. You have to put this within that exception and get this damn thing into pretrial. I don't want to have to report a train wreck here where another federal judge has refused to acknowledge this law. Even if you say that our argument and the facts are completely false, that is absolutely no argument in favor of a judge not even acknowledging the exception. And there is no record of any of the critics stepping to the plate and trying to make an argument as to why the judge doesn't even have to acknowledge the exception. You may have a colorable argument that this doesn't fall within that, but you have no argument that the judge can actually ignore the exception. My number is 218-632-9399. The passcode is 2020 with the pound sign. If you have a lucid, coherent, rational argument that allows a judge discretion to ignore such basic principles of court procedure, such basic procedural due process principles. The idea that a judge can just, no, there is no exception. Anti-injunctive Tax Act, no exception. You can't even get them to put in their order that there is an exception. What does this tell you? It doesn't matter the physical location. All over California, all over the federal system. Not a single judge, but hopefully we can change that this time. Man, there's a mountain of facts to back this up. I mean, a mountain of facts. Just what I have gone through on the show today. And I haven't given you the dates and times. I've given you the names of the agents. But we have the dates and times, and it is all filed. This was a long complaint because of the facts, not the legal arguments, the facts. A lot of stuff to get through, but I gave you a pretty good summarization. And I've personally spoken with Mullen, Marconi, and Jones. So I'm talking from personal first-hand experience. Again, I'll get to the calls in a second. You can dispute the facts here. Reasonable people can dispute the facts. I get that. There is no reasonable dispute, and there's no reasonable argument justifying a judge ignoring the exception to the Anti-Injunctive Tax Act and ignoring the principle on Rule 12b when a motion to dismiss is filed, that all well-pleaded facts must be taken in a light most favorable to the plaintiff. Okay? Even if the facts are ultimately wrong, for the purpose of the motion, favorable to the plaintiff. I like to see that. Well, we got our homework done here. I don't know too many other cases where you can get it as solid as this. Asking for facts is frivolous. We don't have any facts. We don't need facts, and we can't prove it. That's pretty rock solid. Oh, in saying that I'm a scammer, that doesn't negate the facts. That's not an argument. Well, let's get to the calls. I appreciate the patience of me going through this. Covered a lot of ground there. Again, I want to put out, and it will be in the video, but for those listening now, if you want to look it up, I will put it, I should put that in the show notes, but it's Enochs versus Williams Packing and Navigation Company, and I will put that into the chat so you guys can look that up. Well, let's get to the calls. If area code 717, you're live on the No Snake Project. What's your name? Where you calling from?
Hey, what's up, man? It's Ken. I just got your motion for dismissal template, actually.
And you're calling from where?
I'm sorry, go ahead.
Where are you calling from?
I'm in Philadelphia. The shit that happened was in Harrisburg, Pennsylvania.
Philly, the home of Frank Rizzo. Good to hear from
you. You're kind of breaking up here. I want to say, I've been watching and listening to this show for a little bit now, and thought it was pretty fucking crazy for a little while, and the more and more I kind of looked at it and listened and read laws and everything, the more and more it seems to be blatantly obvious that, to me, that it doesn't really seem like most of these quote unquote laws actually do apply to us. At least stupid bullshit where nobody's even actually hurt.
Well,
I also got to say I might have to run early. There's supposed to be an attorney calling me at 6:30, but he's obviously late by this point.
Okay. Well, but let's address what's crazy here. I know on its face, to the uninitiated, someone who hasn't investigated and someone who just has accepted his whole life that laws apply because politicians say so when they buy into the whole founding myth that every country seems to have and somehow is required, and it's required reading to go through that mythology on how Canada, was founded or how ancient Greece was, that the laws, most people don't question whether the constitutional laws apply. It's just accepted. I challenge that, and I get that a lot of people would think, are you out of your mind? What the hell is wrong with you? Of course they apply. Well, if you apply some critical analysis to why you think that's right, and you see me questioning a Supreme Court Chief Justice, a magistrate, I'm questioning law professors, I'm questioning prosecutors, and and IRS agents, when not a single one is able to support that, it doesn't seem nearly as crazy, right?
Yeah, and the other thing is, I get in a lot of debates with a lot of people about a lot of different things, and one thing I've learned is that anytime you're debating with someone and they're posing questions and you just don't even have an answer, you don't have an answer to the opposing party's questions, that to me screams I just lost this debate.
Yes, I do want to throw in here real fast, just because somebody can't, just because I question an IRS agent and they can't support their claim that the Constitution laws apply, that in and of itself is not proof that the argument is false. The facts prove that the argument is false.
This attorney's calling me, and I got to sue some police, so I'll try to call back in.
Okay, all right. More important to talk to the lawyer than me, but I won't take offense at that. I get that is crazy because I went through it myself. And I was alone. This is something that I came to the realization on my own that there was no state and it was all BS because I saw that, all 50 states and the feds, that there was no duty to protect. And I was like, but wait a minute. I know what a citizen is supposed to be. I've read their laws. I've read their cases. I've looked at the Massachusetts Constitution. Okay. Supreme law. And I know it's very consistent that there's a duty that goes back, before in American Anglo law, it goes back before the Magna Carta. That there's this so-called relationship of protection and allegiance. And then I read Spooner, who brought it home that it was never legitimate to begin with because it was always by force. It wasn't that they just decided to, and became criminal. It was criminal right from the start. And I could not argue with the facts. Well, you can say, well, but people voted for the Constitution. Well, some of them did. Sure, there's historical evidence to prove that. There's no reasonable dispute. They didn't have a choice on whether it was a government itself. And that is the key issue. And you can go back to 1774, 1775, and 1776. And nobody had a choice in the original 12. Somebody may have referenced, Rhode Island did not, they adopted as their state constitution, when they became a state, they adopted the original colonial charter. And then I think later they did have a convention. But nobody had a choice in those. And again, even if they did, it wasn't everybody. It was only it was landed, wealthy white people. And all of them are dead anyway. But they weren't even the wealthy landowners that could vote if they were given a chance. They didn't have a choice of whether there was the government or not. So I can certainly appreciate the initial, you've got to be crazy. Because I get it all the time now, because they laugh. So if you watch the video with Scott Bales, he initially laughs at the suggestion. Now, laughing didn't help him out of the situation. It didn't help him form a logical argument, because it's not logical to say that the fact that they prosecute and put other people in prison proves that the Constitution, a written instrument, put that in there too, applies to me and creates obligations on me. And yes, I did follow that up after they shut me up, and I couldn't keep talking to him. So when we were out in the rotunda, he wouldn't let me record him, and he refused. He just laughed again. It was funny. So I asked him, how exactly does prosecuting and putting other people in prison prove that this written instrument applies to me? And he thought it was funny. Again, he probably never gave it any thought. And so what else do you do when you're somebody who is a respected individual, who's the most respected, and you just gave, and I'll admit, it was a great lecture, and some non-lawyer, some schmuck from Long Island, who can barely speak properly, ask a question that you should be able to answer, and you can't. So, a friend from Philly, I totally understand. A lot of people, there are people that I work with that still have a problem. Can I really go in and make these challenges? Yeah, and you can be successful. You have to look at the facts. What are they accusing you of? What do I say on the show every time? And I do this on Consult. You have to look at their actual arguments. And again, I have plenty of proof of this. I have critics that I've had on the show that I've asked. I've had plenty of bureaucrats. We know what the basic argument or allegation is. We know. There's no ifs, ands, or buts about it. It's not up for reasonable debate. We can ask them and they will tell us. If you're physically in the United States, the laws apply, and there's jurisdiction, and that those laws create obligations on you, positive and negative obligations on you. That is the allegation. When you're in court, it is you're physically in Arizona, the laws apply, and you violated them. Now, if you're going to defend yourself, which I hope you would, because even if you're going to get a deal, you can get a deal on your own. You don't need a lawyer to do this. So this is why I talk about, again, this is for new people. You have the allegation being used against you to separate you from a certain portion of your money or your time. Okay? Separate you from your family, your life. We know that this is what it is, and they'll tell us. We've got plenty of evidence. Nobody is pulling this out of thin air. In fact, the critics all believe that, yes, the laws apply, end of discussion, and it's not even a matter of fact. It just does. Okay? We've addressed this. It just does crap. That's not logical. That's not beyond a reasonable doubt. That's not by a preponderance of evidence. That does not satisfy due process. Say it just does. And if you think saying it just does is a sufficient legal argument, then why can't we get away with that? Okay? It's okay for the prosecutor. Again, proven it is a criminal organization and the game is fixed. It's rigged. So is it crazy to take the literal allegation that's being used against you and to question them on it? Now, if you believe in sacred cows, yeah. Well, you know, I agree, Mark, that you should zealously challenge the allegations against you. Well, should we challenge the foundation that the allegation that the laws apply in the first place? Well, that's crazy. That's crazy. Is it unreasonable? Is it illogical? No, of course not. So we have to get over the initial crazy, and that this is unorthodox, but it is reasonable, it is rational, and it has been very effective. Why is it that on cross-examination, every time you ask, did you make this legal allegation or this legal determination? Yeah. What facts did you base it on? Objection, calls for legal conclusion. No, it doesn't. No, it doesn't. So why does every judge sustain an off-point objection? You think one judge would say, oh, this is not Florida. Oh, no, you're not in Dick Noble's court here, Mr. Prosecutor. You don't get to make an off-point objection like that. Denied. And if you ask make an off-point objection like that, you're going to go to jail for contempt or, $100. They don't do that. They uniformly stick up for him. Why? Because they cannot prove it. And say this to people who say they don't have to prove that. Ask him if you can. Can you prove it? Can this be proven? Because if you can't prove the first part, you can't prove the second part. Because the first part you have to assume. Well, Mark, we're going to just assume you're alive in 1963, and then we'll prove you killed that Kennedy son of a bitch. You're working on behalf of the Jews. So yeah, if you don't have to prove I wasn't born till years later. It's a matter of being a skeptic and stepping outside of the church called the state and the theology known as statism, and having the audacity to question it. Because the worst that happens is you just confirm that the belief is true. That you have a true, justified belief. Knowledge. But it's taken as a matter of religious faith. I'm not saying there's a God involved, but it's taken as faith. You just have to accept it's true because it is. And my response to that is the part that's crazy. My questioning whether that's true and encouraging people to challenge that is not crazy. Challenging an assumption, challenging a claim is not crazy. Accepting it on faith, accepting it as true, especially from someone who is actively trying to hurt you, that is crazy. I'm just going to accept what the prosecution said is true. And I'm going to defend myself from there. Well, why are you drawing a line? So if we line up the prosecution's claims against you, the very foundation is that you're physically in Canada and the laws apply. Why would you draw the line there and not challenge that when the entire rest of the prosecution's case hinges literally on that? This is why I talk about being a skeptic and using basic principles of logic. And don't believe this garbage that logic isn't a part of law. Maybe not in practice, but those what the rules are based on. Relevance. Relevance. My gosh, the principle of relevance. I can't tell you how many times I've had prosecutors stand up screaming objection relevance. Whether it's on point or not. It's one of the biggest objections that they make. Why? Because there's a certain logical progression, the way you lay out your case, the way you lay out a cross-examination, the way you lay out a direct examination. If you want to prove your proposition, you have to support it with facts by your premises, that one naturally follows to the other, and that the premises form a logical conclusion. So that without giving you the conclusion, if I just lay out my premises, you'll be able to fill in the conclusion because your premises are sufficient to prove that. But if you skip part 1 and 2 and you just present 3 and 4, oh, you can use inductive reasoning in court, yeah. But for circumstantial evidence. But the one has to follow. It has to create a picture. It still has to prove beyond a reasonable doubt the proposition. How can they prove that you are guilty of not having a driver's license when they can't prove, and they admit they can't prove, that you're required to have one in the first place? I'm not talking about right to travel here. I'm not talking about legal interpretation. I'm talking strictly on the lack of evidence they have to support their claim. I just went through what we'll be presenting in court. Those are the facts. What do those facts tell you without me even giving you a conclusion? Asking for facts is frivolous. We don't have the evidence. We don't need the evidence. We don't need to prove that. What do those facts tell you without me giving you a conclusion? They speak for themselves. Unlike, he doesn't have a driver's license. Okay. He doesn't have a driver's license. So what? So what? I would get back to the calls, but I am out of time. So, hey, Mark, you didn't answer my question. I didn't see it. Sorry, I wasn't going through the questions there. Didn't see your question. We'll have to get that on another show. I wasn't watching that. But hey, I covered a lot of ground here today. I mean, if you disagree with what I've said, well, that's fine. Be a skeptic. Again, I've worked with people that wanted to fight a traffic ticket, but were an anarchist. And you have to discuss why this is effective. Without even becoming an anarchist, you wipe the slate clean and just look at their arguments and see if they can prove it. Not whether you think it's true. Does the record support this claim? That's what's important. Does my wife pay taxes? Yeah, most people do. Most people do. Most of the people that watch probably listen to the show or follow the show, do. Most taxes, some taxes can be avoided, which we do, and some taxes can't be avoided, like going and getting gas in the car. You can't avoid that as far as I know. Although, I'm sure there are ways to do that, and I've worked with some people that we're able to do that. Few and far between, and typically a very dangerous road to go. But if you disagree with what I presented, that is cool. And you're more than welcome to call into a live broadcast, and I'll even record a show. But just know, if you talk over me, I'm going to either dump you or I'm going to use the mute button, or I'll use the mute button until it becomes time to dump you. Okay? That's one of the few things here. We don't have to use filthy language. We don't have to use insults. We don't talk over each other. A rational argument. Okay? Think of it as, like the argument clinic. That's fine. But you have to bring your facts. You have to bring your evidence. Okay? You have to have your logic. You have to address the actual argument. You can't be like a politician and say, well, Mark, you're saying that the Constitution doesn't exist. I'm not saying that. I don't know who you're actually talking to. But not me. Address the argument. And then I can, I have no problem. I had somebody call. We spent an hour and a half talking about ethics. We had an argument about ethics. Wasn't a crossword in the whole thing. So if you disagree, if you think that there is evidence proving that these written instruments apply, or evidence to show that what we call government is legitimate, if you can make a ethical or moral argument for government, I'd love to hear it. So far, not a single person could do it, including the entire staff at of lawyers, professors at the ASU Law School, including the ethics professor who told me he couldn't in an email, politely turning me down. But if you think you can do that, call. But I do appreciate everyone tuning into the big show today. Again, I'm going to do my best to record live on Friday, so look for that. This has been episode 99 of the big show for February 13th, 2019. I appreciate the support of the show. If you would like to support the show, and it is very much appreciated, needed, you may do so at markstevens.cells.com, or just go into the website, markstevens.net. Until next time, salud.